Hello and welcome to our podcast at Get Legally Speaking. Our legal conversation today will be about commercial law for small businesses. I am here today with barrister Mr. Jonathan Miller from 1 Essex Court Chambers in London. Jonathan Miller is a senior barrister specialising in commercial litigation. He has advised numerous businesses of all sizes on the wide range of problems and difficulties encountered in the world of business. He has acted for both purchasers and suppliers, lenders and borrowers, employers and employees, and also shareholders sitting on both sides of the fence. Thank you for joining us, Jonathan.
It's a pleasure, Hatti.
Excellent. Right.
Hatti, you know that commercial law for small businesses can be summed up in 3 words.
No, not at all, not at all. And, well, how would you sum it up in 3 words, actually?
Read the contract.
I love that. That's a good point, and a very, very important one, actually. Provided there is a contract to read, I will say. So let's get on to our first most frequently asked question about this area of law, Jonathan. And we started off by hitting a really key point about read the contract and if there is one. But let's start really from the beginning of setting up a small business. So the first question is, I'm setting up a new business. What are the pros and cons of setting up a limited company?
Well, setting up a limited company has one big advantage, which is that the company itself has what lawyers call a separate legal personality, and the effect of this in everyday life is limited liability, and the limited liability is the limited liability of the shareholders in the company. Now, there are some other aspects of a limited company which are perhaps less relevant to small businesses. It's often said that one of the advantages of a limited company is the separation of ownership and management. So the shareholders don't necessarily need to get involved in the management of the company, and the directors who are involved in the management don't necessarily have to be the owners. But this is perhaps less of an advantage in many small businesses where the shareholders, the owners, and the directors, i.e. the management, are the same people.
So let me just take you back to what we said in the beginning there with relation to the limited company being a separate entity to the actual owner, right? In the sense that it limits liability to the owner. So as an owner of the business, if I own a limited company, the company is a being in itself.
Yes, it's an artificial concept and sometimes can be quite difficult to grasp. But the company is a separate thing, a separate personality from its owners, the shareholders, and from its directors.
And therefore we have limited liability on the directors. The company is itself, the limited company, takes the responsibility for a lot of things.
Yes, the company is liable on the company's contracts. The shareholders and the directors are not. Now, having said that, this is one of those things which has got lots of loopholes, exclusions, and pitfalls for the unwary.
Yes.
But the basic principle is, yes, the company is liable for its debts. The shareholders and the directors are not. So their liability is limited. The shareholders' liability is limited to the share capital.
So that's a big plus, isn't it? That's a big benefit to having a limited company. Can we think of something that's not beneficial? Would you say, an obvious reason why it's not beneficial to have a limited company? So a pro, because we said pros and cons of setting up a limited company.
Well, there's a list of them, and it can be summed up, I think, by the fact that as soon as you have a limited company, things start to get more legalistic. So the ability to trade with limited liability is something of a privilege, and the privilege has to be paid for by increased formality. So more formality in decision making may be required. You have to comply with the Companies Act. Filing your accounts. That's an important point, actually, Hatti, because one of the things you lose is you lose a certain amount of your own privacy. So if you're just trading on your own account, obviously there's some things you have to do. You have to file tax returns and keep records, but
as an individual just trading, yes, without the limited
absolutely
company.
It's not very different from just being a private individual. Well, you are just a private individual, but a company is a public thing. It's on a register. Its accounts have to be made public. In order for the accounts to be made public, returns have to be made.
Your profit or loss is made public.
Yes.
The registered address, which doesn't need to be your home address, but your registered address for your business.
Yes. All sorts of... They're relatively minor things, but they're things which add up. You're no longer quite as...
discreet
sort of
or in the background.
Discreet or in the background, yes. You start to appear on public registers and people can check up on you, which is the whole point. I mean, the whole point of the Register of Companies and the whole point of this information is so that clients, customers, suppliers, anyone that's going to lend money or thinking of lending money can
or do business
carry out
with
some
you.
checks.
Yeah,
yes.
Can look to say, who is this company? How long have they been around? So this, who owns them? Where is their registered office? And certainly, if you ever need to take legal action against a company, you need to issue a claim and serve it at the registered office.
Exactly.
Yes, very important. Okay, well that's really helpful, very useful information. The second question we're going to look at, Jonathan, is, and it's a big question because lots of people actually, I think, and I have seen over the years, have avoided going into business because they feel that their personal belongings, being assets by way of property, maybe the house they live in, the car they own, are at risk. And this is a question which lots of people want to know the answer to. If my business is sued, is my personal property at risk? If my limited company is sued, we're saying here.
Yes, because if you're self-employed, the answer is obviously yes. Your personal property
if
is
you're
at risk.
self-employed, but if you're a limited company,
you might think that it follows from the principle of limited liability that if you trade through a company, your personal property is not at risk. I mentioned earlier on that there's a number of qualifications to the principle of limited liability, and in the business world, it's impossible to isolate your personal property from risk altogether. You're okay as long as the company itself is good for its contractual obligations, and you're okay provided that the company remains solvent. But the danger area happens if the company can't pay its debts and becomes insolvent, and there's a whole range of quite terrifying provisions in the Insolvency Act covering the recourse that can be made to directors in particular.
So if your company is going insolvent and it owns millions and millions of pounds, what we're saying is, can a creditor come after your personal property, even if the property is not secured or a guarantor by any way on the business?
Well, the person to watch out for is the liquidator of the company.
Yes.
So
yes.
The liquidator of the company in those circumstances will be trying to get in as many assets of the company in liquidation as possible, and to build up a fund that he can distribute to the creditors. And one of the targets which they do look for in those circumstances is the director or the directors. Now, in a well-run company, this should not be a problem, but the provisions of the Insolvency Act can be quite draconian, the one that catches a lot of people out is the concept of wrongful trading. So running an insolvent company while it is basically insolvent, but just keeping it going and carrying on sort of running up debts when perhaps the proper thing to do, if people had taken advice earlier, would have been to wind it up earlier in an orderly fashion.
So what we're saying is here, if you're running a business that you know is insolvent, it cannot afford to run, but you're still running it, you're being, negligent in a way to your creditors, because you're saying, I'm running it, it's really insolvent, but I'm still running it, and then you rack up so much debt that if a liquidator has to come in, an insolvency practitioner has to come in, and they may look at your property even though it's not part of the business because you've been naughty, you've refused to give up. Some people genuinely don't mean to do the wrong thing, but they hold on because perhaps the next big contract might come in, or they were promised, maybe they were owed money. There's so many reasons why people go insolvent or liquidate, for example. But yes, so essentially it doesn't always mean that your personal property will not come into play if you're sued and you have an insolvency practitioner, for example, come in to dissolve your business and try to pay your creditors. It doesn't always mean your personal property will not be taken into consideration. It could be, is what we're saying. It could be. It's a risk. As I said, in well-run companies, this shouldn't be a problem. But the classic instance of trading while insolvent is hoping that something is going to turn up and trying to trade out of one's problems. If one takes proper advice from well, in this case, it would be probably from an insolvency practitioner. That is a safeguard. It's the sort of recklessly carrying on business when the more sensible thing to do would be to just wind it up. That's where the risk starts. And if you don't become insolvent, it's not a risk. There's a few other pitfalls to that, though. There's a few other pitfalls. You can. There's a whole industry really, which is dedicated to trying to make directors liable for the contracts of their company. The quid pro quo of limited liability is creditors who don't get paid, and then they've got no recourse to go to. So people do try to make directors liable. That there's a classic pitfall might be making a representation, i.e. a statement that your company is able to make a payment when in fact you know that it doesn't have any money in the bank. That's the sort of thing which can lead to personal liability on the basis of the person making the statement. The other real life problem is, of course, that even with limited liability, you may find that major suppliers, banks, other people, principally landlords. Major suppliers, landlords, need some sort of personal guarantee. So you're then on the hook on your personal guarantee, quite independently of the company. And I think that's a very important point, because you've got to be very careful when thinking you've been asked to give a personal guarantee, and at the time you may not fully understand what that means, or what, in the unfortunate event that the business doesn't go as planned, are you personally liable? If you've given a personal guarantee, I think it's safe to say there is absolutely no doubt you're personal liable if you've given for what you've given a personal guarantee for. But if you haven't given that personal guarantee and you've done everything as correctly as required, and the insolvency practitioners come in, or you're about to liquidate, then there's less likely a chance that your personal property could be taken into consideration if you've done everything properly, and you got into insolvency and you've taken the advice and you've not said anything you shouldn't have said, or practiced when you really shouldn't have been practicing. So yes, I mean,
generally speaking, in a well-run and organised company that's run in a careful manner, then your liabilities, as far as your personal property is concerned, in the everyday reality of the business world, are most likely to be triggered by a guarantee. And guarantees are always signed in a spirit of optimism.
Yes.
They're signed when great news, the bank have agreed to give us a loan.
Yes.
Everyone thinks everything is going to go terrifically, and very often it does. But that's the point at which the guarantee is signed. Very often people don't even read them; they just put their name at the bottom.
That's very true.
And everything's fine until suddenly, 10 years later, things might not be going so well, and the guarantee that people have probably forgotten about at this stage suddenly reappears and is called in.
Yes, yeah. So obviously, what we're saying is, if you're ever asked to give a personal guarantee as part of your company business and what's going on,
remember it's there.
Yes, remember it's there. Well, think very carefully before you commit to it. I mean, sometimes it's one of those situations in life where with it you can progress your business, because what you're going to get on the back of providing the guarantee is going to be really key to your business. And sometimes you think, well, if I don't do this, then I can't grow. So I get it. It can be challenging times, but take as much advice as possible from accountants, from the legal world, from insolvency practitioners, if that's what you need to do, liquidators, and then make the best judgment, as we all try to do. So, yes, well, next question, only question 3, and we are heading fast and furiously into time, which is great, actually, is what is the difference between being self-employed and being a sole trader?
They're the same thing.
Exactly the same thing.
They're exactly the same thing.
So they're just different terminologies. Being self-employed and a sole trader is exactly the same thing.
Yes, HMRC tend to use the phrase self-employed, but it's the same thing. Self-employed, sole trader, same thing.
Well, that was nice and simple. It's nice to find some simplicity in the law sometimes, Jonathan.
That'll be the last one.
So, next question. Who are Companies House? What is Companies House? What do they do? We know that, as a fact, more than 4 million limited companies are registered in the UK. Over 500,000 new companies are incorporated each year. That's a big number. So what are Companies House? Who are they? Who are they run by?
Companies House is a government agency. It registers company information and it makes it available to the public. So this is going back to what I was saying earlier about how once you incorporate a limited company, you start to lose privacy. That's because it's on a register. The register is kept by Companies House. It's a very large repository of information.
And it does sort of include directors' full names, date of birth, the share capital holding. So if there's lots of directors holding various amounts of shares, or one director, who the company secretary is, the registered office.
The detail they keep is quite extensive. So all companies have to file an annual return
To do with the finances of the business.
Well, it gives the company's details, the principal business activity, company type, registered office address, location of company records, the names of the company officers, statements of capital, who the shareholders are, voting rights, and that's the annual return. Now, in addition, you have to notify Companies House of any changes to the company officers, new directors, resignations, changes of their personal details, and you have to file annual accounts. Now, for small businesses, those actually can be relatively simple, the annual accounts, balance sheet, profit and loss, accompanying notes. It becomes much more complicated if you are a sizable business, but for anyone whose turnover is below approximately £10 million, it's the accounts don't need to go into the level of detail that they do if it's a
And they
public
file
limited company.
abbreviated accounts.
If you're a very small company, you can file abridged
Which
accounts,
means-
which is barely more than one page. Although they still have to be a true and fair view of the company's financial
of
position.
course.
So just because they're abbreviated, that doesn't mean that you can put any old thing in them. But the amount of detail doesn't need to be that extensive.
Okay. So I think this is sadly going to have to be our last question because of what we've got time for. So we're talking about employees in companies, and the next question is: do I have to pay redundancy to employees if I cannot afford to employ them anymore? So as a business, as a limited company here we're talking about, I guess, do I have to pay redundancy money to employees that I haven't got the money to employ anymore?
Well, here's a proper lawyer's answer. This is an extraordinarily complicated question.
It's always good to start that way.
Redundancy is the word which is much bandied about generally. But in law, it's a precisely defined concept. So not being able to afford to pay employees doesn't necessarily mean they are redundant. Redundant, it's got a lengthy definition in the Employment Rights Act, but the concept is really more a question of we are not doing so much of that type of work at that particular location, so we don't need so many people. It's a question of the
job itself.
The job itself, and that can be a job at a particular spot.
So let me just hold on. I need to get this clear in my head. If you can't afford to pay your staff, it doesn't mean that you can make them redundant.
It doesn't mean that
Doesn't
they're
fall
redundant.
under redundancy.
What it probably means, if you simply can't afford to pay them, is that you need a genuine business reorganisation based on economic necessity. Now, that's quite a complicated phrase, but I choose those words deliberately because a genuine business reorganisation based on economic necessity is, or can be, a fair reason for dismissal. For dismissal. So redundancy is a reason for dismissal, but a genuine, simply not being able to pay the employees suggests that the business needs to be reorganised, make some economies, take some austerity type measures, and that's probably going to be a fair reason for a dismissal. Notice the use of the words probably there. All these things depend very, very much
on the
individual facts.
Yes. So do you have to pay redundancy pay if you're making employees redundant?
If it's a genuine redundancy, yes, you do have to pay them.
And there's obviously a statutory
There's a
calculation as a bare minimum.
There's a statutory calculation. It's quite it's actually quite a straightforward calculation, but just set out in a rather complicated
Well, why wouldn't it
way.
be, Jonathan? It's the government delivering the message.
So it implies that any employee who's been employed for a minimum of 2 years, and you look at their
on a full-time or part-time basis. Probably doesn't matter.
If they're an employee, they're an employee, whether they're full-time or part-time. You look at their weekly gross remuneration. Note gross remuneration there. Now that's subject to a maximum of £525 gross pay per week. So that if it's more than £525, it's capped at that. And then you multiply it by a factor which is basically determined by age and length of service. Half a week's pay for each full year under 22, 1 week's pay for each year between the age of 22 and 40, and 1.5 weeks' pay for every year of service after the age of 41. Length of service is also capped at 20 years, and then there's a complete overall cap at £15,750. That gets raised usually on an annual basis, but that the current figure is £15,750. So it's not a completely open-ended liability, but it can be a fair amount of money.
Yes, it certainly can. I mean, that's very interesting. So yes, even if you can't afford to employ, and if it comes under redundancy, then yes, that you do have to pay redundancy pay by law, and that's probably really interesting information for both the owners of the companies and for the members of staff. But
redundancy is a really tricky area.
Which area of law is not tricky, Jonathan? Maybe we should do a podcast on this area of law is not tricky. So listen to this one. But yes, there is.
It could be a podcast based on what's the difference between self-employed and a sole trader, and that was.
Yes, that would be the
one of the few straightforward points,
wouldn't it?
An awful lot of time in employment tribunals is taken up on the question of whether somebody was or was not redundant, or whether they were unfairly selected for redundancy. It is an area where specialist advice pays premiums, I think. Absolutely. Because it's just it's quite counterintuitive to what people might think. The way they might think that the law operates
and how it will be interpreted.
Yeah.
But that is all we have time for.
Well, it's just flown, Hatti, hasn't it?
It has. I told you, it goes very, very, very quickly. We haven't even scratched the surface, but that's okay, because we will be doing a part 2. And Jonathan, thank you ever so much for taking part.
It was a pleasure. It was a delight and a pleasure.
And I am pleased that we will be doing part 2, part 3, and lots of parts, because there's far too many areas of law in every area of law, and particularly in commercial law for small businesses for us to cover. So don't forget to click and subscribe to our podcasts, and you can find us on Twitter, Facebook and LinkedIn by searching Get Legally Speaking. Also visit our website at getlegallyspeaking.com. Thank you very much for listening.